right, now let's discuss strict liability offenses. A strict liability offense is one where only the actus reus need be present to prove guilt. You may recall that most crimes involve three elements. The actus reus, the person has to have committed the prohibited act. The mens rea, they have to have done so with a guilty mind. And concurrence, the prosecution must prove that the act was committed in that guilty mindset. It was also mentioned that in result-type crimes, it may be necessary to also prove harm was done. However, there are a small number of crimes called strict liability offenses, where only the actus reus need be present to prove guilt. Now, because of that, they also penalize accidental behavior. So some people can commit a strict liability offense by accident or even unknowingly. Consequently, strict liability offenses often have only fines as penalties. Strict liability offenses are usually traffic, health code, and safety code offenses where they're committed by many accidentally. Now, the reason why we still make this a crime is because it's dangerous to allow these behaviors to occur, even accidentally. Let's take traffic, for instance. Believe it or not, most people who speed don't realize they're speeding. That's because traffic studies have shown that most people instinctively drive at a speed which they consider to be safe based upon weather and road and traffic conditions. When people find themselves on a roadway where the speed limit is posted too low, they very often speed accidentally. The same is true of health code violations. A typical health code violation might be citing a restaurant for storing perishable foods at a temperature above 40 degrees where microbes and germs will multiply, risking the chance of food poisoning for people who consume that food. And safety code building violations are another example. Now, again, health code violations can even be committed unknowingly. A restaurant owner or manager might not even know that the temperature in his refrigerator is above 40 because the refrigerator may have broken and he didn't know it at all. And similar things can occur with safety code violations. However, we cannot tolerate and safely live in a society where people can freely speed because it's hard to prove intent, where restaurants can serve spoiled and dangerous food, even accidentally, and of course where building codes violations occur and people's safety are jeopardized, again, even accidentally. So we make these kinds of offenses strict liability. We tell people responsible for them that if you just do the act, you're guilty. So you better be extra careful. So we want the restaurant owner to frequently check the temperature in his refrigerator because he must realize that if it goes high, unbeknownst to him, he's still guilty. So we encourage them to do the right thing and check often. And that's why they're strict liability offenses. Remember, the consequences are grave for society. Speeders make roads unsafe, buildings with construction defects, and restaurants serving spoiled or contaminated foods harm people. So we have to hold people accountable. Okay, now let's talk about vicarious liability. And vicarious liability means criminal liability for the conduct of another. And that means that somebody else did something and you're going to be held liable for what they did. So vicarious liability transfers criminal liability from one person to another based upon the involvement of the other person. And the most common example of vicarious liability is corporate liability, where an employee of a company commits an illegal act as part of his or her work responsibilities. Generally, a corporation is responsible criminally for the acts of its employees when the acts are within the scope of the employee's duties and are committed to benefit the corporation. So let's look at those elements now. So the person has to be an employee of the company, and the person has to be acting within the scope of the employee's duties. So if I am a delivery truck driver for UPS, and while I'm delivering a package, I notice that a door is unlocked and nobody's home, and I sneak in and I steal jewelry, UPS would not be guilty under the vicarious corporate liability concept, because stealing is not part of the scope of my employee duties as a delivery truck driver. So you have to be within the scope of the duties, and it also has to be committed to benefit the corporation. If an employee is working within the scope of their duties, but commits an illegal act to benefit themselves, then the corporation would not be held liable. So if I were a cashier at a store and I purposely shortchanged people to keep the money for myself, even though I'm acting within the scope of my employee duties, I'm not acting to benefit the corporation. So that would not be vicarious liability. And in both those situations, only the delivery driver and the cashier would be guilty, not the companies. But if a corporation had employees breaking the law within the scope of their duties to benefit themselves, then there would be corporate or vicarious liability of the corporation. So if a large company purposely doctors, let's say, auto emissions tests, because their vehicles that they make have to pass an auto emissions standard, if they direct their employees to fudge the data, to lie about the data, to show that the cars passed the test even when they didn't, or to rig the cars so when they take the test they'll pass even though the regular cars don't, and Volkswagen was recently found guilty of this and is paying monumental fines, then the corporation would be guilty. I might also add that the individual who commits the act is also guilty of the act and can also be prosecuted. So if I am fudging data and filing it with the federal government on emission standards on behalf of my company with the corporation's knowledge, obviously, then the corporation is liable, and I too am liable for these false statements and fraudulent statements being made to a government agency. Now we're going to discuss the final element of a crime, causation. And this is required where a result must occur to fulfill the actus reus, and the actor must cause the result. These are result-type crimes where there has to be a result, like a dead body in murder, injuries in an assault case. While concurrence deals with the link between the mens rea, the mental state, and the actus reus, the prohibited act, causation deals with the link between the actus reus and the harm done. And there are two types of causation, and both types must be present for liability to occur. And it's the responsibility or the burden of the prosecutor to prove that both types of causation are present in a result-type crime, and the proof must be beyond a reasonable doubt. The first type of causation is called factual causation, or but-for causation. It must be shown that the bad harm would not have occurred were it not for the action of the actor. In other words, but for Bill shooting James, James wouldn't be dead. So let's take an example. A shoots V and just nicks his arm. B comes along and shoots V in the head and kills him. A would not be guilty of the murder because a nick does not kill anyone. So his shot was not the factual cause of V's death. Of course, B caused V's death, and it is the factual cause, and B would be guilty of the murder. Now, there are limits to the but-for test. Even though V would not be dead were it not for the fact that the gun was manufactured, the gun manufacturer is not guilty of murder for making the murder weapon. That is too tenuous a link back in time for the but-for test. Just like we wouldn't charge B's parents for giving birth to him. Since B wasn't born, he never would have killed V. Again, It has to be a closer factual causation than that. The second type of causation that must be proven is legal causation, also referred to as proximate causation. Here, the actor's conduct must be closely related to the harm done and not too remote or accidental. As an example, in homicide cases, if the victim dies of the wounds more than a year after they were inflicted, many states say the wound is not the legal cause of death because it becomes too remote from the act. Let me give you another example. Many years ago, I guess back in the 70s, there was a very controversial case in Ozone Park, Queens, New York City, right near where I grew up. A few black guys were driving down Cross Bay Boulevard in the Ozone Park section of Queens, and their car broke down. And they got out of the car and they walked to a nearby pizzeria to make a phone call. A white kid who had just left a party, and he might have had a few drinks, saw the black guys in the pizzeria, got into some sort of an altercation or argument with them, or just yelled at them, went back to the party and screamed to his friends at the party, "There are some N-word, I won't say it, in the pizzeria, let's get them." And a crowd of white guys, young men, teens, 20s, went to the pizzeria. And when the black guys saw them coming like they were a mob, they ran. One of the black guys ran into a nearby parkway, and he was being chased. And he ran across the roadway, and in so doing was hit by a car and killed. Now, in a case like that, there is legal causation. There is proximate causation. And that's because it is reasonable to assume that if you're chasing somebody with a club to kill them or seriously hurt them, that they're going to run. And they might even run across a road where they get hit by a car. So that, even though the people chasing him didn't kill him, the fact that they were chasing him and that was why he ran into a road and was hit by a car and killed, that is close enough to be legal causation. Now, let's change that a little bit, and let's say that this guy escaped and he was safe, and he was taking a subway home, and while he was waiting on the subway tracks, somebody accidentally bumped him and he fell into the track and he was run over by a train and killed. Well, even though he never would have been in that subway station taking that train, had that white group of kids not chased him and tried to injure or kill him, that becomes too remote a connection between the death and those white kids who were chasing him, where they would not be guilty of any homicide offense towards him. Now, let me assure you that in most cases, causation is usually quite obvious and is not a legal issue. But in some unusual cases, it is a very interesting and complicated issue. I haven't discussed it here, but it becomes even more complicated when you talk about issues like an intervening cause, which is an event that comes between the initial action and the end result, which kind of mixes up the connection, or superseding causes, which can override initial causes. I mean, the lawyers think up all sorts of scenarios, which occur in life. So it's a lot more complicated than we presented here, but this is not law school. So what I've told you so far gives you a decent grounding in the idea of causation, certainly enough for this course. And that concludes this lesson.